Members of the jury, this case has been an inordinately long one, but it has been tried by two adroit lawyers, and we gain this advantage from it, that very little is left for me to say to you. If you do not understand what the issues are in this case now, it is useless for me to try to explain them to you. Of course, if you get to the issue of damages, it signifies that you should consider carefully what dollar sum ought to be awarded to these plaintiffs. There are two plaintiffs, you understand, and you are to render two verdicts. The wife sues for her own personal injuries. If she recovers, she gets that money for herself, that neither her husband or anyone else can touch without her consent. The recovery is for her pain and suffering, her disability in the past and in the future. So far as from the testimony you believe that her injuries or their effects will exist in the future, and that sum must be fair and reasonable compensation. As to the husband, if you get to the question of damages, he is suing for his own personal injuries, not so serious as the wife's, but still, as he claims, they were material. If you get to this question of damages, he will be entirely or entitled to reasonable compensation for his pain and suffering, his disability, and his loss of earning. There is a second cause of action while he is suing, that is, for the expenses that fell upon him because of the injuries to his wife. He is responsible for her two doctors' bills. He is responsible, of course, for the extra help hired that he has been testifying to, and also generally for the loss of consortium of his wife. Of course, if you get to the question of damages, he is entitled to compensation for those losses, fair and reasonable to him, and fair and reasonable to the defendant. Now, the law says that if these liabilities, fair and reasonable and adequate compensation should be awarded. I can lay down no set rules for your guidance on that question of damages, but if you get to that question, the compensation should be fair and reasonable to the plaintiffs and fair and reasonable to the defendants. The most important question in the case, far more important than the question of damages, is the question as to whether you should give anything. The question of liability. The mere happening of an accident does not in and of itself mean that somebody else opposed the accident through negligence. The question of negligence is the great question that is litigated here. When two vehicles on Fifth Avenue collide, it is a reasonable presumption that someone has been negligent, either one of the drivers or both of the drivers. You have heard the testimony. I do not need to discuss it, particularly after the able summation that we have listened to. Each of the drivers, the driver of the Ford car and the defendant's driver, under the circumstances in which they found themselves crossing the road, was obliged to conduct himself with due regard for the right of others using the highway. All law, rules of the road, and the ordinances governing driving are common sense, and that implies due consideration for others who may be using the highway at the same time that you are using it. The signal concerning which you have heard testimony is important to the defendant as bearing upon the question of the negligence of his driver. Yet, signaling is not always enough. The driver of a car must have his eyes wide open to see what traffic there is, to see how close it is, to see and conduct himself adequately and accordingly. The testimony in behalf of the plaintiffs is that the car of the defendant was further from the defendant than was the Ford car, and was in the collision and in which the plaintiffs were riding. If that is the case, it would appear that the other car cut across the Ford car, which is perfectly proper and may be done, provided there is reasonable opportunity to do it without infringing upon the right of the other car. If there are two cars going along abreast, and one car is going to cut across and go in that direction, it is not merely enough to signal and then cut across, because the other car may be so close that a collision is inevitable. The signal must be given to the other car so that the other car ought to see it in time so that it will have reasonable opportunity to safeguard itself from harm by reason of the other car going across. Of course, the defendant's story is entirely different. The defendant says that he was in a line of cars next to the center of the street, that his car did not attempt to cut across, that his chauffeur did signal in due time, and that he started to go across. From the defendant's testimony, it might appear, and you would be warranted in finding, that the car moved out of line and that the Ford car came up in a hurry and caught them before they had an opportunity to make the turn. You remember the testimony. Each driver is required to use common sense and to respect the rights of the other. That is all there is to it. As the person in the street would say, who was to blame for the accident? The law always talks of negligence, but the ordinary person says, well, who was to blame? You have heard the testimony. The burden of proof is upon the plaintiffs to show that this accident happened through the negligence of the defendant. That is, the driver of the car, the person for whose negligence the defendant is responsible. If the accident happened while through the negligence of the driver of the Ford car, of course there can be no recovery.
That's fair. Your first 30 seconds were really fast and the last 30 seconds were really fast.
Read the first.